Hello, everyone. Welcome back to Law on Obligations and Contracts. So, our topic for tonight is about the form of contracts. Under Article 1356, contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. Remember the principle of consensuality of contract? Di ba sabi natin na in consensuality of contract, it means that contracts are perfected by mere consent. There is no requirement that the contract or the subject matter of the contract should be delivered or that the contract should be reduced into writing. Because under the law, generally, contracts are consensual in nature. Okay, this Article 1356 applies only to consensual contracts. Formal contracts must comply with the form required by law. However, the general rule has exceptions. And we said in our previous discussion that there are two exceptions to the general rule. Number one, if the law requires that the thing or the object, which is the subject matter of the contract, should be delivered, then the contract is no longer a consensual contract, but a real contract. And the other one is that if the law requires that the contract should be reduced into writing, whether private or public instrument. So in that case, the contract is no longer a consensual contract, but a formal contract. So let us continue reading Article 1356. However, when the law requires that a contract be in some form in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. In such cases, the right of the party stated in the following article cannot be exercised. If, by reason of non-compliance with the requirement, the contract is not valid or unenforceable. So there are certain contracts which the law requires to be put into writing. But then again, if the law does not provide for its form, then the general rule will apply. It means that the contract can be perfected by mere consent. So what are those contracts which the law requires to be in writing? Number one example is donation of real property. So the law requires that donation of real property be made in a public instrument. When you say it must be made in a public instrument, it means that the document must have been notarized before a notary public. So when you say private instrument, wala siyang it does not bear the notarial seal of a notary public. Second is if you donate a personal property with a value exceeding 500 pesos. Under the law, for it to be valid or enforceable, it must be made in writing. Pwede private instrument only. So if you will donate personal property like cell phone or laptop, and the value exceeds 500 pesos, so that should be reduced into writing, at least a private instrument. The third one is stipulation to pay interest on loans, interest for the use of the money. The law also requires that in order for a lender to impose interest on the principal amount borrowed by the borrower, the obligation to pay interest must be reduced into writing. So even if the loan itself is not reduced into writing, dapat yung payment of interest, magkano yung interest rate, the term, and the obligation to pay interest should be in writing for it to be valid. Otherwise, if you have secured or obtained a loan and that loan has an interest but without any written instrument proving the imposition of interest, then the payment of interest is not valid. No, the imposition of interest is not valid kasi sabi ng batas, it must be in writing. Fourth one is sale of land through an agent. So here, since it is the agent that transacts with the prospective buyer, the agent should be armed with a special power of attorney, which must be in writing and notarized by a notary public. So dapat, if you will authorize someone to sell your land, you must execute, no, as the principal, you must execute an authority in favor of your agent. So any person who will deal with an agent should look for his authority, which is in writing. Otherwise, if the agent does not have the authority to sell, then that transaction will not be valid. Any contract entered into with the agent without a written authority is not valid. Fifth, contract of Antichrist. The principal loan and the interest, if any, must be specified in writing. Ano yung common example ng contract of Antichrist? Example nito, yung meron kang agricultural land, for example, you use that agricultural land as a collateral. So ginamit mo yung lupa mo para mag-collateral ka, kumuha ka ng loan. Ngayon, yung agreement ninyo is yung mga fruits or yung mga harvest mo from that agricultural land will go to the lender. So, sa pinag-utangan mo, pangbayad ng principal at saka ng interest ng loan. Sabi ng batas, if that is the case, it should be specified in writing. Kasi ang mangyayari niyan, kapag nag-enter ka into contract of Antichrist, yung lender mismo ang gagamit sa agricultural land mo. Siya ang mag-harvest, siya magbibenta ng hinarvest mo, ng mga fruits and vegetables, whatever, na nakatanim dyan sa lupa mo. And then, the lender will apply it to the loan and the interest. Unlike ordinary loans na kahit na magbigay ka ng collateral, hindi naman yun ginagamit ng lender yung collateral mo in contract of mortgage, in ordinary contract of loan with collateral. But with contract of Antichrist, this is a special one kasi yung lender mismo ang gagamit ng lupa. Siya mag-harvest, siyang magtitil, etc. So therefore, sabi ng batas, in order to protect the rights of the borrower, that particular contract of Antichrist should be in writing. Article 1357. If the law requires a document or other special form for convenience, as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form once the contract has been perfected. The right may be exercised simultaneously with the action upon the contract. The article applies only when form is needed only for convenience, not for validity or enforceability. Thus, the contract must be valid and enforceable in order for the contracting parties to compel each other to observe the form needed for convenience. A contract partly written and partly oral is in legal effect an oral contract. So in the case of Manuel versus Rodriguez, GR number L-13435. So let's go to Article 1358. The following must appear in a public document. So sabi natin kanina, na-mention natin na pag sinabing public document, it means that the document must have been notarized, acknowledged and notarized before a notary public. So sino yung notary public? Isa yung lawyer, no? That has the authority to notarize documents. So here in Article 1358, we will know kung ano yung mga contracts na dapat notarized ng isang notary public. So first, acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable property. Sales of real property or of an interest therein are governed by Articles 1403 number 2 and 1405. So, if yung contract daw is or any acts or contracts na ang effect niya is to transmit real rights or extinguish real rights over immovable property, it should appear in a public document. So an example of this is if you will mortgage your real property. O kung in layman pa yan, kung gagamitin mo yung lupa mo as collateral to your loan. So there is a there is a creation of real right over immovable property. Bakit may creation? Kasi yung person na to whom the property was mortgaged will have a real right over the immovable property. And what is that real right? The real right is if in case you fail to pay the loan amount, then the creditor or the mortgagee will have the real right to foreclose your property. So that yung property bebenta, then kung may proceeds, yun yung ibabayad sa loan. So nagkaroon ng real rights over immovable property by executing a real estate mortgage. So sabi ng batas, kung yan ang mangyayari, kung may creation of real rights over immovable property, then dapat yung kontrata na yan should be in a public instrument. Okay? Second, cession or renunciation of hereditary rights or of those of the conjugal partnership of gains. Okay, so eto, paano natin to i-explain? Diba, pag may namatay, kapag may naiwan siyang properties, yung properties na naiwan niya mapupunta sa heirs. Ngayon, what if for example, yung isang heir doon, let us say yung asawa niya na naiwan, will renounce her share from the conjugal partnership of gains. I-renounce niya in favor of her children. So, magkakaroon ngayon ng waiver of rights, di ba? Kasi i-waive niya, i-renounce niya in favor sa mga anak niya. Kasi supposedly, dapat, kapag namatay yung spouse, yung surviving spouse, isa siyang heir and therefore magmamana siya sa kung anumang property ang naiwan ng deceased spouse. Pero, what if for example, yung surviving spouse, nag-renounce siya, nag-waive siya ng kanyang right in favor sa kanyang mga anak. Para maging valid yung kontrata na yan, sabi ng batas, it must be in a public instrument. Otherwise, walang magiging proof no, na meron talagang renunciation. Kasi waiver yan ng rights. Merong parang ayaw mo nang i-claim, ibibigay mo na sa anak mo. So ano ngayon ang proof? Kailangan it should be in writing and must be notarized by a notary public. Third, the power to administer property or any other power which has for its object an act appearing or which should appear in a public document or should prejudice a third person. So for example, if you will leave, for example, the Philippines in order to study abroad, let us say for 2 years. And you have properties left in the Philippines. And for you to still manage your property, you appointed another person to manage your property or to administer your property in the Philippines. Under the law, if that is the case, the authority of the person you want to administer your property must appear in a public document. Okay, that is an example. Fourth one is the cession of actions or rights proceeding from an act appearing in a public document. So an example is demortgage his land to C to secure the payment of a debt. This mortgage appears in a public document. The decision by C of his right as mortgagee to T must also be in a public document. Okay. Ang ibig sabihin lang nito, if for example, C will transfer his rights to another person or he will parang i-transfer niya yung right niya over the property, then yung pag-transfer din ng right na yan should be in a public document. All other contracts where the amount involved exceeds 500 pesos must appear in writing, even a private one. So ito yung mga personal properties exceeding 500 pesos. Kailangan in a private document. But sales of goods, chattels, or things in action are governed by Articles 1403 number 2 and 1405. So we will discuss that later. The necessity for the public document in the contract enumerated here is only for convenience, not for validity or enforceability. For enforceability lang pala itong Article 1358 and 1357. So it doesn't mean na if the act or contract is not reduced into a public document, it doesn't mean that the contract is not valid. Ano lang siya, for convenience, what rights ang ma-acquire ng person under Article 1358? Ang right na ma-acquire niya is to compel the other party to observe the form needed for convenience. So that's for form of contracts under Chapter 3. See you next video. Goodbye.